going forward.
I call Andrew Williams.
Thank you, Mr Speaker. I take a call in the second reading of the Crown Minerals Amendment Act bill. And this is becoming bigger than Texas, effectively. It's being blown out of all proportions, and all sorts of other spurious sort of arguments are being thrown in the mix, when basically what we're talking about here is sorting out a piece of legislation that unfortunately was originally drafted with an oversight in it, which is now needing to be rectified, so that the original legislation that was to come into effect on the 24th of May, next week, can come into effect in a correct manner. If it doesn't, it impacts on the original legislation, and it means the original legislation is left wanting, and it means that New Zealand and our economy and the opportunities within this are left wanting as well. And if we could just sort of simplify it down, what the original legislation overlooked was the fact that in exploration, in mining, in looking for resources, often there are the equivalent of similar to a rugby team or a soccer team or a football team. There are talent scout type organisations who are looking for the potential and the opportunities in this particular industry, and they are sort of the scouts and the ones that are going out there in advance and looking at what is the potential of the minerals or of the resources, but they themselves don't necessarily have the full capacity, the full technical ability, or indeed the financial strength to undertake the actual mining, drilling or exploration that subsequently ensues. And what they do is they set the parameters, perhaps secure the permits, do all the initial exploration, do the initial findings, research, geotech and all these various things to ascertain whether there is a future. And if there is a future, that can then be escalated. And then, as they talk here in the legislation, you then have farm-ins and farm-outs, and then it might go to the next where a much bigger operator would then come in and take over and take it to the next stage. Unfortunately, the original legislation did not allow for that exploration type work to be approved under the original legislation, and effectively, therefore, on the 24th of May in a week's time, many of those exploratory companies would not effectively be able to continue to operate in the manner that they would, and it would be an impasse, and that would not be good. That would put a great deal of uncertainty within the industry, and indeed it could pull the rug out from underneath some opportunities that are occurring in terms of mineral exploration and research in this country. So this is legislation. This amendment improves the legislation. It gets it right. It sorts out what was an error in terms of the original drafting. The original legislation was only here 3 or 4 weeks ago in the House. New Zealand First supported it at that time. We do believe in economic development in this country. We do believe in sustainable, responsible development of our resources. That would not be the case if this amendment was not passed, because it simply would kneecap the original legislation if this was not passed, and it would make it very difficult for the original legislation to proceed as it was intended and as it was intended by this House. So New Zealand First will support this bill, and we do believe that it is in the interests of the New Zealand economy and the interests of New Zealanders that this does proceed and that this is sorted out, put on a correct footing, and that the interests of the overall economy are put first in this.
Call Kanwaljit Singh Bakshi.
Thank you, Mr Speaker.